Chapter 30. The Equity System of Pleading and Practice, Sec. 165. Its history should be studied. Equity and law now under the code system is administered by one and the same court. To understand the system perfectly, it is necessary that its history, going back to the time when courts of equity were separate and distinct from the courts of law, should be studied. We must have in mind the origin and history of equity jurisprudence. It is common knowledge that equity came into existence only to relieve against the many hardships of the law. By reason of the manner in which equity afforded relief, it was perfectly natural that in the beginning of the system it was administered by a separate and distinct court. To illustrate, if a man enters into a contract with another by which it was stipulated and agreed that one should sell to the other certain real estate, and there was a refusal to perform, the one who suffered injury could, if he went into a court of law, only recover damages in money. In many cases that may be an entirely inadequate remedy, therefore he could go into a court of equity and there present the facts to the chancellor, who, not guided by set forms and precedents, could act as his conscience and best judgment dictated. In other words, the chancellor could grant specific relief. He could compel the party to specifically perform the contract by the execution of the deed for the property to the vendee according to the terms of their contract, and if he failed to comply with such an order, the decree may be made to serve the purpose of a conveyance. Necessarily the machinery for administering the rights of parties, legal and equitable, had to be different, and at first the idea was not conceived that the two could be united in one court, as they were so entirely different from each other. Sec. 166. How equity administered now. Under the present procedure in most jurisdictions, law and equity are administered by one judge and one court. But this court acts in the same manner as did the separate court under the former procedure. The same rules of practice, the same rules of procedure, and the same principles of law, control the actions of the present court of equity. In jurisdictions where there is more than one judge, there is a separate chancery room where the cases in equity are assigned and tried, and presided over by one judge called chancellor. Sec. 167. The system in England, the foundation of all equity practice as well as equity jurisprudence, lies in the English High Court of Chancery. But on account of the many abuses and absurdities which prevail in the chancery practice in England, the equity practice of that country is now essentially different in many respects from the ancient system. The Act of 1873 abolished some of the unnecessary offices, diminished the offices and emoluments, and provided that suits in equity were to be commenced by a writ prepared by the plaintiff issued under the official seal instead of the old subpoena under the Great Seal. When the Judicature Act of 1873 was passed in England, there were numerous improvements made in chancery practice and procedure. Law and equity were to be thereafter administered concurrently by every division of the court in all civil matters, the same relief being granted upon equitable claims or defense, as would have been previously granted in the Court of Chancery. Sec. 168. In the United States courts. In the United States courts, practice in equity is still pursued in its strictest form, the difference between the common law and chancery practice being preserved very largely as it existed in earlier times. Although administered by the same court,